see you here. I hope this will be perhaps a little different than what you're used to hearing as far as reasonable accommodations, but we'll get to this here shortly and get underway. I'd sing, but then you'd leave. And I'm a terrible dancer, so I'm just curious to know while we're warming this up. Are you all HR personnel? No. Who here handles ADA accommodations for your employees? Okay. Okay, that's quite a few of you. Okay, and I guess while this is warming up, what do you consider to be your biggest challenge you go through this morass of the ADA and other disability protections? Okay. Matching up what the employee wants with what the supervisor can tolerate and what the county can afford. Okay. That kind of sums it up. I think we're done. Okay. Mel.
Brian, there's two levels for everything involved with discipline. So you get the accommodation requests once discipline action is finished.
Okay.
So you can't perform your jobs outside.
Well, it's the same song that we sing, so we'll sing it together as we go through this. Just a few things. This is not legal information. If you have a legal question, see your lawyer, okay? Don't bother me with your legal questions. I can answer. Okay, second, we're going to talk about some situations. They're not real. If you think they're real, get over it, okay? Now, the way reasonable accommodations work and the way it seems to work, or the frustration of it, both from an employee or an employee standpoint, can, I think, be summarized with this video. I hope you can hear it. Now, I hope you can hope it works. I'll tell you what I'm going to do. Where's my drive? Right here? Okay. Here you go.
Hi, are there any local companies that rent anti-gravity machines?
Anti-gravity?
That's right, yeah.
What do they do exactly?
They make you feel lighter.
Anti-gravity. I'm really doing some of that.
Okay.
Okay. Sometimes accommodation requests that come in may seem that far out. And there's a beginning of a dialogue that hopefully takes place, but it often seems like it comes from outer space. On the other hand, I think it's important for us to remember something. I just anecdotally, we had an experience not too long ago where one of our ADA coordinators in one of our largest agencies called and said, I need an accommodation request, Brian, but I'm afraid to ask my supervisor. And this was a gentleman who knew what the protections were, what the law was, what the machinations of it, of the whole process are, and yet he was terrified to ask his supervisor, who was also an HR professional, for a simple accommodation. And I mention this only because, and I show this video only to illustrate something that we often forget, those of us who are in these trenches day in and day out, that is a very, very difficult thing for most employees to even come forward and ask for something. And so when they even get to that point, let's set aside the disciplinary issues for a moment. But when they get to that point, they have really kind of laid things out there in a way, and sometimes they feel like they're risking their job. So, takeaway number one from this presentation, I hope, is that when you receive a request, even if it may sound like they want an anti-gravity machine, which we can't create or present or purchase, take that seriously, treat them with dignity and respect, and that alone will avoid claims and problems down the road, is how you accept what's being asked. Okay, let's move on. I'm going to run through a bunch of these slides. We're trying to get out of here. Dee, again, tell me what time you want me to stop.
Oh, I want you to present your material. That's why we're here.
Okay.
We were hoping somewhere, let's just, let's a little bit, maybe 1:45 would be.
Okay, and I'll try to get done sooner. But if you have questions, I'd rather talk than just present. Okay, you just had lunch and I'm going to probably put you to sleep. So let's talk. Okay, we'll keep each other awake. Okay, this is language right out of the ADAAA Amendments Act that was passed in 2008, effective 2009. So we've had it now for over 3 years. This is very, very significant language. Basically, the law is saying, and when you look at it in the overall context, you employers and you courts stop getting hung up on the definition of disability. Be focusing more on what you should be doing to accommodate. And stop messing around with all your analytical charades in terms of determining whether one is covered under the ADA. It should not demand extensive analysis. Okay? That's the change. Big change. And as you all know, or you should know if you don't, the threshold for coverage under the ADA has been lowered substantially. People who weren't covered previously are now, in many cases, covered. And so our whole line of thinking has to change, and it probably has for all of you. But if you have any questions about that, make sure that you're talking to your lawyer and getting the right direction there. This is the EEOC's final rule, and of course the benefit of this, or the enforceability of this is pertinent, because in this case, the Congress actually mandated that the EEOC promulgate these rules, so they have enforceability now in the courts, whereas the previous guidances that were out there didn't necessarily have that same weight. Okay, so this is the rule, this is what we're supposed to be doing as employers. And we have a defense, don't we? Undue hardship. Now, most of us in government, with the budgets we have, depending on your budget, in a lot of cases, we're not going to be able to make a financial hardship argument. In some cases, we might. But we also have defense of other administrative hardships, or hardships that would fundamentally alter the course and scope of business. But you've got to do this on a case-by-case basis. Okay, and that's the bottom line. It's always individualized. You can't assume one thing crosses over into another. One individual's disability or accommodations that were granted should be the same for any other employee with the same condition. Employers don't have to do these things. They don't have to eliminate essential functions. They don't have to change production standards. They don't have to provide personal use items unless there's a need, and which includes personal assistive services. Okay? That's not required under the ADA. Things like hot pots or refrigerators are generally not required unless they're needed for that employee to meet job requirements. Okay? And we're going to talk through some hypotheticals of some of these things as we go on. This is what employers must do. This is right out of the EEOC guidance and regulations. These are accommodations that are expected to be made, provided there's not an undue hardship. Adjustments to application processes, changes to the work environment, barrier removals, and then obviously modification of policies and practices. And we're going to talk more about that too. These are other types of accommodation that are anticipated and are things that we need to be looking at whenever there's a request made. And here is the EEOC guidance. This is really the best practice as to what employers should do. And those of us, we're all Title II entities under the ADA. And under Title II, we are expected to give deference to an employee who requests an accommodation as to what he or she wants. We don't have to give them that. Ultimately, it's our right as an employer to select. But under Title II, we are obligated to defer to the employee's request for the specific accommodation based upon the assumption that the employee with a disability knows what he or she needs to address that disability better than we do. Okay? They've had a history that we're not familiar with. These are essential interactive steps. One of the things that we do, we actually have a worksheet for all ADA coordinators throughout the state where they go through these steps. And one of the steps at the very end is that they have to contact the Job Accommodation Network if they have any questions and through that process. And they have to check that off that they've done that. But these are the essential interactive steps that are absolutely critical to an effective interactive process. This is something that employers forget from time to time, that there really is a hierarchy. You really must accommodate the employee first in his or her workplace, at his or her job. Then you can look to, if need be, and it's not an undue hardship, actually have the employee work from home in the case of the telework issue. And then ultimately, the last and final accommodation is reassignment to another available vacant position. Let me illustrate how this is sometimes forgotten. You may have a situation where an employee requests leave. There's a doctor's note that comes in that says, look, this employee is having a hard time being at work and needs rest. And so this employee needs some time off or needs some relief during the day. And we've seen where an employer will say, well, let's grant this employee FMLA leave so he or she can have unpaid leave and protected leave as an accommodation. Does that fit within this hierarchy? No. They skip the essential step of analyzing whether something can be done in the workplace, some accommodation can be extended so that the employee can stay at work. Can there be a place for the employee to take more frequent breaks or take a rest so that they can stay there and get paid instead of going home and not getting paid? This is something that is missed from time to time where employers will jump to FMLA and forget about the obligation to accommodate so that they can stay at work. With respect to the request, this is how the whole thing starts. No magic language is required. All there has to be is a stated need as to how work can be changed or what's needed to help the employee conduct work to a health condition. That's it. You have those two elements, you've got a request for accommodation. And you as an employer then have a duty to now go down the road of the interactive process to see what can be done reasonably. This is a really significant, I'm sorry if I'm standing in your way, but ultimately the employer's obligation and liability to that employer is dependent upon what the employer knew or should have known. And so, as you well know, this request can also come from a doctor's note, from a spouse, even from a responsible child. Typically, it'd be an adult child that you'd look to for that kind of information. Okay, and then this speaks to how they open the door. Employees are not required to propose specific accommodations. And then these are the elements of a failure to accommodate claim. Okay? Disability, knowledge of the disability, a request for an accommodation, a failure to provide that request, and then it could have been. Okay, I have a few cases here. I want to go through them and talk about them. They're not, many of them are not here in the 10th Circuit, but they're very illustrative of some principles that I think we need to know. In this particular case, this is a very interesting case. Employee had cerebral palsy and was hired as a pharmacy technician, pharmacy assistant actually. And he had no, surprise, no write-ups in his performance reviews, no history of bad performance or conduct. New supervisor comes in, which is when we sometimes have issues, and starts giving him a hard time and writing him up for things that he really wasn't doing. Okay? What I mean by that is writing him up falsely. And over time, this supervisor persuaded him to just transfer or to be reassigned to a position where he ended up working out, bringing carts in, and then he ultimately terminated him when the supervisor assigned him to another schedule that conflicted with his community college classes that he was attending and that they knew about when they hired him. And so you've got a situation where you've got ugly facts, you've got a really bad employer. I'm not saying Walmart is necessarily a bad employer, but they're sued a lot by the EEOC. But in this particular case, the court took a very interesting position of saying, you knew he had cerebral palsy. You knew that he was challenged on the job. And looking at what the employer did to really discriminate against him in their overt actions, punish them by saying you should have engaged in the interactive process because of what you knew about him. Okay, this case is up here. Remember, every case is so case specific, and the laws, the ADAAA are federal. We have state laws as well that may figure into some of these decisions, but this case to me means that if you as an employer know there's an obvious disability and you're engaging in overt or even covert acts of discrimination and not accommodating an employee so that he or she can succeed on the job, or at least to level the playing field, then you could be subject to these kinds of problems. This is another situation again. These cases just deal with whether or not there was a quantum of knowledge for the employer to have to do things. In this case, a pharmacy supervisor, regional supervisor, had a diabetes-related blackout while driving. And in that case, in just about every jurisdiction, there's usually a 90-day revocation of driver's permit. Asked that the route be reduced so that he could just be taken by cab or by family to stores in a smaller area, without explaining to his supervisor that he needed that because of his diabetes. He just said, I need a smaller area. So there wasn't that nexus. Now what's interesting about a lot of these cases, and I'm not going to have time to go through all of them, is that by the time they're up here to the Court of Appeals, they probably have spent easily $250,000 just litigating the thing. And a very proactive ADA coordinator can even avoid it getting to this point by engaging and being proactive. I'm going to move past some of these cases because I want to talk about some things. The bottom line is that these cases are saying that you've got to have that nexus. There's got to be sufficient information for an employer to be now on duty to go ahead and engage in the interactive process. Now, I put this case in here because I can't believe the calls I still get from time to time from some of our insurers saying, in fact, I got one a few weeks ago. they had hired an employee, and employee, they knew that he was deaf or hard of hearing. And he asked for the NEO, the new employee orientation training, that he could have a sign language interpreter there. Okay, what do you think, folks? Okay, no doubt, right? But this HR person was thinking, why do I have, that's going to be expensive. Now am I going to have an interpreter for every meeting for this employee we hired, and regretting now that they had hired this employee. Okay, it's a no-brainer, but still some people miss the boat. This is a 10th Circuit decision that we were intimately involved in that there was a nurse who was severely injured, almost killed by an inmate, after she was left alone with an inmate with known proclivities toward violence against women in particular. And after that occurred, we got involved and made recommendations that they actually prepare those who are going to treat these inmates and elevate the standards, the essential functions, to include post-certification, help protect them. In this particular case, this employee couldn't pass the tests. We're talking about qualification standards here now. But what was interesting here is that the plaintiff claimed that the Department of Corrections did not engage in the interactive process in good faith, when in fact they had offered her a new position, said, look, you're going to have to meet this qualification standard. It's a new standard, we know, but the court upheld a new qualification standard as an essential function. But the court ultimately held that, look, the defendant, Department of Corrections, did everything it could, including offering you another job by way of reassignment, and you declined that. And so the employer's duty was done. So a big deal, as you know, is that the employee has an obligation to engage in good faith in the interactive process. Okay. I hope you don't mind my doing this, but I think I may have lost. Well, I'm not going to go to the trouble of doing that. How many of you have seen the Red Green Show? Okay? This is an excerpt from the Red Green Show. Won't be able to show it to you here, but we'll go back. Red Green in this video shows how he's able to take a pickup truck, an old beater pickup truck, and create automatic window openers. And the way he did it is he took a mixer, battery-operated mixer, got rid of the little spatula things, whatever you call those, beaters, thank you. And was able to use those just to jam them onto the, after you pulled the handle off the window opener, you could jam that onto there and roll the window up and down with that battery-operated piece of equipment. If you want it, I can send it to you. It's not that funny, but it's pretty good. In that it illustrates how simple some of these accommodations can be. It takes just a little creativity. We had a situation up at one of our universities where a student who was in an anatomy class was required to work on cadavers, had a struggle because she had some mobility challenges and was in a wheelchair, but couldn't reach up onto the surgical tables to participate in the class with her fellow students. And so they struggled with what to do. They looked at buying an adjustable table that would have cost about $15,000. And they looked at all kinds of other solutions. Ultimately, the student decided, actually suggested, can you put the cadaver on the floor? And I'll get down so that I can participate that way. Didn't have to buy a thing. The student was happy. They just used a little gray matter to come up with a creative solution. Okay, now we're going to talk, this is where things get kind of fun. We've just been talking about kind of the dry stuff, but let's talk about stuff that really gets challenging, okay? These to me are like the top 10 types of accommodations that we wrestle with day in and day out. Okay, so we're going to cover these. So let's move on. Vasectomies, you know what those are, right? Okay, we're going to talk about a vasectomy. Okay. So here's a scenario, and we're going to talk through this scenario. Okay, Debbie wants a new supervisor because of PTSD. All right? When you ask why, she says that the supervisor is triggering that PTSD, and it makes it very difficult for her to work. Okay? What's the rule about requesting a new supervisor? Is that a reasonable request? No. Okay. Very clear, black and white. It's never a reasonable request to ask for a new boss. Okay? Does that mean you're done? I mean, can you imagine all the work we have to do if that were, we had to accommodate that? Okay. So are we done? Can we just say no and say case closed? No. Okay. Explain why no.
Well, I would want to know why she thinks her boss is triggering her PTSD. What are the incidents, the issues? 9 times out of 10, she'll look at the boss, it's the activities that she's.
Okay. So you're going to want to explore further. And why do you want to explore further? You still don't have to move the boss, right? So why even go through that?
Sometimes I don't think employees realize that they're the problem, it's the boss.
Okay.
So the dialogue helps.
Right. You've got to still engage in the interactive process. You can't drop the ball here. And one of the things that I see more often than I'm happy about is employers who will take the position that, look, unreasonable request, done. Knee jerk, we're finished. Instead of doing exactly what you say, where you still engage in the interactive process to see if other accommodations can be implemented there to keep her there, right? Because that's your first responsibility in the hierarchy of accommodations, to keep the employee there. Okay, now, let's add to this hypothetical. Let's suppose that you get a note from her psychiatrist that says, as a result of childhood abuse, sexual abuse, and other abuse, this supervisor reminds her of her stepfather who sexually abused her for years and is absolutely not able to stay there. Then what do you do? Come on, you bright ADA thinking people. What do you do? Okay, are there any other openings? Okay, so you're looking at reassignment, aren't you? Now, do you have to do that? Not necessarily, but it's probably a good practice, don't you think? To see if there's another solution in an available vacant position. But the reason I have that there is to illustrate that you can't just let this one go. You got to go down the road and make sure you're accommodating. And the ADA contemplates that supervisors may have to change or would have to change their practices and policies if reasonable to accommodate these kinds of things. Maybe putting things in writing, other forms of instruction would help in a case like this. Okay, let's move on. This is right out of the EEOC enforcement guidance. Their answer to that question is no, you don't have to change a person's supervisor. Anyway, let's move on. Let's talk about reassignment. We finished vasectomy. We're now on to reassignment, which we brought up here. Okay, 2 months ago, David, a police officer, has returned from his second tour of duty in the Middle East. Last month, he was an arresting officer in a DUI, and he tased the suspect 9 times. Okay? He's also refused instructions and has told a co-worker that he wants to die. Okay? Okay, now, this is where we interact. Okay? What do you do here? Let's sit down and talk about this. Okay? Now, what would you do, Mel?
This is harsh, but if the employee has committed a violation, you would normally terminate people for cause, tasing the suspect 9 times. There's not a disability that can defend that kind of behavior that you have to accommodate.
Okay.
It's not that far.
So you're looking first to your consistent disciplinary practices, your policies, and treating it that way without looking to a disability. Great. Thank you. Hey, might you, if you have a practice of looking into this and trying to rehabilitate your employees, might you look at a fitness for duty? Okay, it's another option. But I like Mel's best. You start with your conduct and performance management before you move to a fitness for duty. Okay? Okay, let's move on. So the psychologist, say you send him out for fitness for duty.
Is there a timing sequence to that, though?
What's that?
Well, if Mel started first, then you could move down that path, but they've already laid things out, this, and then you come back and start disciplining them. Doesn't it almost give them more honor, if you will, to their position? You're not helping me, you're disciplining me now.
You know, it certainly gives them an argument, but if you are, and again, case by case, work with your lawyers, but if this is prohibited conduct by your policy, and you terminate or otherwise discipline any employee, irrespective of disability, you can and should consistently discipline this employee as you would any other employee. Now, if the employee is, and there's an argument out there that if you don't, you're discriminating against an employee because he or she has a disability. You're treating that person differently by not disciplining them and treating them the way you would every other employee. Now, that may be a benefit to that employee ultimately. They cut them some slack. But ultimately, you need to treat them all the same. Now, let's say during this process, he comes forward and says, look, I need some accommodations at work. I need some leave. I need some time off to see my therapist to get through this stuff. Then you go down that path at the same time. But that doesn't necessarily stop you or have to stop you from engaging in consistent discipline. Okay? So let's send out for fitness for duty. Okay? So a psychologist conducts a mental health fitness for duty and determines that Dave is not fit for duty. Okay? Also opines that Dave's restorability is unlikely. Restorability meaning the likelihood of coming back to work in his position due to rigid intractability and nature of conditions. So what do you do there? Let's say your practice is that you don't terminate. You try to find a way to rehabilitate and restore. And that's your practice. And a lot of law enforcement folks do that. Okay? Because of the inherent, I'm not going to speak to whether that's good or bad, but that's just what happens. Okay? So what do you do here? Can't be a trooper, Clark says. So, what do? You talked about it earlier. Okay, you're reassigned. you have an obligation to look for available vacant positions for which he is qualified. That is absolutely a clear rule in our circuit. Okay? It's very clear here in the 10th Circuit that you have to do that. So, you then just place it there, or do you talk to the fitness for duty psychologist to make sure that that's a good fit? You do that? Okay. All right. Let's move on. These are the really hard and fast rules, case by case, with respect to reassignment. Have to be qualified, don't have to promote, has to be an available vacant position. Vacant means it's available when they ask for a reasonable accommodation, or you know it's going to become vacant in the immediate future. Okay? And there's a whole different argument about how long you have to hold jobs open and all that. Our practice is to hold them open at least 60 to 90 days. That's what we do. I mean, what I mean by that is search for available vacant positions for about 60 to 90 days. Okay? You have to first try to find a job that's equal pay and benefits. If there's not, then it can be a job with lesser pay and benefits. Again, I'm just going to kind of move this along. You don't have to create a position, and again, it's the last resort. Now, this is an interesting bullet point here as to whether you have to look agency-wide or county-wide or statewide for an available vacant position. The EOC and the Department of Justice are very clear in saying, yes, you do. But the 7th Circuit disagrees on a number of those issues, so if there's a split as well now. But we've had a 10th Circuit decision in the city of Denver where they failed to reassign police officers and firefighters to clerical positions, and that was deemed to be a pattern of practice of discrimination. Okay, let's look at this telecommuting thing. You know, can I have someone with a bold and loud voice read this for everyone? How about you right there? Right, you right there. Will you read this for us? Yeah. Oh, this gentleman right here.
Sure. I don't know how to hold my voice there.
Okay.
Randy, an IT manager, has asked to telework due to her fibromyalgia, chronic fatigue syndrome, and irritable bowel syndrome. Randy's department has a policy prohibiting telework for employees with a history of conduct or performance issues. And Randy's teleworking relative were revoked 2 years ago because she found she was working elsewhere and was not always responsive when called.
Okay. Okay, this is a case where there's an accommodation request made. It pertains to a policy. Okay, you've got health conditions that, depending upon the circumstances, may not have always been covered now before, but they are now. Okay. In this particular case, I would think you'd want to make the assumption that there is coverage, unless there's something to show otherwise. But let's just assume there's coverage in all these slides. Okay. So, what do you do, folks? Can you say to her, I'm sorry, you violated our policy before, we're not going to let you telework now? Can you do that?
You could, or you could put her on a real restrictive, so it won't do it, but more accountability back and forth.
Okay. Okay. Give her another chance.
And then the structure doesn't work.
Okay. Great. Okay. All right. We have a policy against you teleworking if you've had a problem before, but remember, you have to look at variations or deviations from policy if it's not an undue hardship, right? In this case, why not? I mean, I don't know about you guys, but I'm in the business of risk management. I don't want a lawsuit. And if we have a lawsuit, I want to win. It's summary judgment. So in this particular case, I'm going to take the safer approach and say, let's let her telework. Let's set the conditions and be very clear as to expectations and manage it. And if she's messing up again, then we can pull it. Okay? But to just take and take the position that, I'm sorry, our policy won't allow us to extend that to you because you've messed up before, we put you in the hot seat again. Okay? And managers and supervisors don't get this stuff. Go ahead.
So what's the purpose of having a policy?
Okay.
Why do you have that policy?
Okay, we have a question. Why even have this policy if you can't enforce it? Okay. Anyone want to respond to that? Okay. Go ahead. Okay. The bottom line is, yeah, we can enforce policies as long as we enforce them consistently and apply them consistently. What's interesting in this, with respect to this hypothetical situation, is that we learned that other people were allowed to telework. We found inconsistent applications. And as you all know, before you say no to a request like this, you better darn well be asking, how are you treating other employees who don't have health conditions? Are you letting them telework? Are you being consistent there? And 9 times out of 10, I find that they're stepping in. You know, they're really not doing a very good job of being consistent. And so, but I agree. Yes.
Well, there's policy, and then we need to look at what practice.
Right. Exactly. And remember, what we're talking about here, this request, we're talking about civil rights versus a company policy. Okay? When it comes down to it, this is a civil rights request. If you don't have an undue hardship to justify a no to that request, you better grant the request. Okay? Now, does that mean you always have to waive your policies and make deviations from them? No. It really depends on how we'll get to a case. This one right here, this is the materials you can read that. This case here, this is a 10th Circuit case. It's a 2004 case. This is a remarkable case on this issue, okay? Ms. Mason worked in a post office in the Midwest where she witnessed a number of her co-workers killed in what they called post office massacre. This is kind of where the go postal thing comes from, or is reinforced. She was then transferred to work for a post office here in this circuit, and didn't see, but learned that a co-worker had pulled a knife, had a hit list, and had threatened to go postal himself and had a cache of weapons. He was gone for a while, fitness for duty stuff. When she learned he was going to come back, understandably, she was terrified because of what she had witnessed. So she asked if she could tell him, please let me work from home. I can't handle the stress of even thinking this might happen again.